Hi, welcome back to my channel. Please like, comment, and subscribe. Who qualifies as seamen? The Jones Act's key provisions apply to a specific class of workers called seamen. This legal distinction is crucial to understand when filing an injury claim. However, there is no binding definition of what exactly qualifies as a seaman anywhere in the Merchant Marine Act or the Jones Act. Some maritime workers do not qualify and may need to seek benefits under the Longshore and Harbor Compensation Act instead. Simply, being employed on a vessel does not in itself qualify as being a seaman. Maritime attorneys on both sides must review prior cases to determine if plaintiffs qualify as seamen. In lieu of legal definition, most judges and maritime lawyers usually agree that a Jones Act seaman is an individual employed or engaged in any capacity on board a vessel, except for sailing school students or instructors or scientific personnel. Over the years, the general definition has undergone change and is still subject to revision. What qualifies as negligence under the Jones Act? Under the Jones Act, maritime employers must provide seamen with reasonably safe working conditions and exercise ordinary care to ensure that the vessel remains in safe condition. To make a successful Jones Act claim, you will need to prove that your employer failed in this duty. Some common causes of maritime accidents that may be covered under the Jones Act include, but are certainly not limited to, poorly maintained equipment, lack of sufficient training, negligent hiring practices, or failure to fire an employee with a known pattern of dangerous or violent behaviors, violations of safety regulations, failure to notify seamen of dangerous conditions such as a wet or oily surface. If you are familiar with what negligence usually means in other personal injury cases like car accidents or premises liability, it is important to note that the burden of proof is lower for Jones Act cases. In other types of negligence cases, you need to prove that the at-fault party's negligence played a significant role in causing the injury. However, in a Jones Act case, you only need to show that your employer's negligence contributed at least partially to the accident, even if it only played a minor role. What benefits are available under the Jones Act? If you live in the greater Louisville, Kentucky or Jeffersonville, Indiana areas and were hurt while working for a vessel on the Ohio River, the Louisville Jones Act attorneys at the Carl Truman Law Office may be able to help you recover the Jones Act benefits that you need. Under the Jones Act, injured seamen are entitled to pursue some categories of damages available in typical personal injury cases. This includes medical bills, rehabilitation expenses, and other past and future medical treatment costs related to the injury. Lost wages, past and present, during the recovery period. Vocational training, if catastrophic injuries prohibit an injured worker from returning to their previous job, but they can be trained to work a different job. Pain and suffering, emotional trauma, and other non-economic damages that affect your quality of life. This is very different from most other types of workplace injury incident, in which injured workers cannot sue their direct employers, but instead receive workers' compensation benefits. The advantage of Jones Act claim is that you can receive compensation for non-economic damages like pain and suffering, which is not possible under Workers' Compensation Act. However, the downside is that you must prove negligence, which can be difficult, costly, and time-consuming. Due to the complexities Jones Act claims, it is advisable to work with a knowledgeable Jones Act attorney to ensure your best chance for timely approval of full benefits. What is the Jones Act statute of limitations? So, under the Jones Act, injured seamen have the right to sue their employers for negligence within 3 years of the date of the injury. There are, however, exceptions to this rule. For example, if you are a seaman who is assigned to a vessel that is owned, operated, or contracted by the United States government, you may have a shorter amount of time in which to file your case. Conversely, if you were exposed to benzene or asbestos dust and were not aware of your injury until a later date, the statute of limitation is extended to 3 years after the date you first become aware of your injury or illness. What if I do not qualify as a seaman? If you are a worker who does not qualify as a seaman, you can still pursue damages under the Longshore and Harbour Workers' Compensation Act. This federal law covers harbor construction workers, shipbuilders, and dock workers who are hurt in the wharf area of harbor. LWHCA provisions are different than standard workers' compensation laws and can often provide better compensation. Common Ohio River barge accidents. As one of the nation's busiest waterways, the Ohio River is used extensively for transport throughout the year. The thousands of barge, tugboat, or other workers who are employed in any capacity in river transport deserve a safe working environment. Maritime and transport companies have a duty to properly train their employees on safety practices and, above all, they must create a safe working environment for their employees. On-deck accidents. The majority of river work-related injuries happen during the day, during regular working hours. On-deck river accidents are often caused by unsecured cargo, unsecured swinging cables, tripping on objects, falls on unsecured ladders, slipping on wet catwalks and stairs, overboard accidents, fire and explosions. Fire and explosion on water vessels can result in catastrophic burn injury. These devastating events can be caused by a number of factors such as first, tank leaks, then combustible materials on deck, defective fuel lines, improperly stored fuel, dock accidents. Not all accidents occur on vessels. Dock accidents can happen during the maintenance or cleaning of a boat, or during loading or unloading. It is important to remember that any injured worker on a vessel, whether on the water or docked, may be eligible for compensation if he or she is hurt in preventable accident. Dam and lock accidents. Both boat crews and dock workers can suffer serious injury from malfunctioning dams and locks. Proper operation of dams and locks is crucial to ensuring a safe river working environment. Any operational failure in this system can result in severe injury or death. Injured on the Ohio River. Contact a Jones Act and Maritime attorney today. Maritime law is very complex and encompasses many rules, agreements, and statutes. Some cases may be tried in state courts, while others may fall under federal court jurisdiction. Due to these complexities, it is critical to choose a maritime law attorney with the experience, knowledge, and resources necessary to effectively handle every aspect of your case. Thank you so much for watching. Don't forget to like, comment, and subscribe.